Hi everyone, in this video we're going to be talking about the making of the Indian Constitution. And if you're in grade 11 studying CBSE Legal Studies, this is Chapter 3 of Unit 3. Also, the information in this video will hopefully be helpful in preparing for the CLAT exam. So let's get into it, the making of the Indian Constitution. So the first thing we're going to talk about is that by 1945, that is by World War II, it was pretty clear that India would become independent very shortly. So around this time, the major political leaders of India had to come up with a constitution to govern India when it became independent. So at the end of 45 in the winter, there were elections for India's provincial legislatures. So there were elections, and these legislatures, once they were elected the members of the Constituent Assembly. So the legislators elected the members of the Constituent Assembly, and the Constituent Assembly, with the drafting committee, drafted our Constitution. Now, the Constituent Assembly, and let me write some of this down. The Constituent Assembly. We'll move that here. The Constituent Assembly mainly had Congress members. So mainly were the members of the INC, that is Indian National Congress. And there were also some other individuals who had extreme knowledge in foreign relations and policy drafting, as well as some communists, but they were mainly members of the Indian National Congress. And the drafting committee drafted the Constitution. And the drafting committee was headed by Mr. Bhimrao Ambedkar, our first law minister, Bhimrao Ambedkar, or B.R. Ambedkar. So that was the drafting committee. Now, you will notice that there are two pictures here. Now, the first picture, this one right here, is A.O. Hume. He's A.O. Hume, or Alan Octavian Hume, or I'll just do the same color. A.O. Hume. And he was a Britishman who founded the Indian National Congress. So in a way, the Indian National Congress was the major player in drafting of the Constitution, and that was founded by A.O. Hume, a Britishman. And the second picture here, well, you might not recognize this man. This man is actually the first interim president of the Constituent Assembly. So the first president of the Constituent Assembly. Any guesses who he is? Well, if you guessed Dr. Sachidananda Sinha, you are correct. This man is Dr. Sachidananda Sinha. Dananda Sinha. This man is Dr. Sachidananda Sinha, and he was the first interim president of the Constituent Assembly, and he was president for about 6 months, and then Rajendra Prasad became the next president. And there we have it. The Constituent Assembly, which was headed by initially Dr. Sachidananda Sinha, consisted of Congress members. The Congress was founded by A.O. Hume. That was much earlier, of course, but whatever. And the drafting committee was headed by B.R. Ambedkar. Now, let's move down a little bit. Okay. So now we're going to talk about the sources of the Indian Constitution. Sources. Put that there. Okay. So the Indian Constitution has 3 sources, and these sources were sort of used, or guidelines, when they wrote the Constitution, because, it's never easy writing a Constitution, and the sources acted as guidelines. The first of them was the Government of India Act 1935. That was the first source. And the Government of India Act was passed by British Parliament when India was still a part of Britain, and it had some salient features which came to define the Indian Constitution as well. The Government of India Act provided for a parliamentary system of government. It created a federal system with a strong center, and it had different administrative aspects. So the points here, I'll just put an asterisk here. It had a parliamentary system. It had administrative aspects. Administrative aspects, and federalism. Federalism. And these were the three features of the Government of India Act, and they were adopted in our modern constitution as well. Now, the second source is the constitutions of other countries. The constitutions of other countries. So other constitutions. And the other constitutions were mainly used in the areas of fundamental rights and directive principles of state policy. So the fundamental rights, we've heard of them before, include the right to equality and right of equality before law and freedom of speech and religious freedoms, etc. And the directive principles are things that would have been very nice to have in India. Things like right to clean air, to breathe, equal pay for equal work, etc. But they're not exactly enforceable in any court of law. So let's write that down. The other constitutions were mainly used in fundamental rights, and directive principles. And the last source is the objectives resolution. The objectives resolution. And the objectives resolution was basically based on old Congress Party documents. It was written by Jawaharlal Nehru. It was written by Prime Minister Nehru. So we'll write that down. Written. And it basically has the main philosophy that the Constitution would eventually espouse. Something like justice, social, economic, political equality of status, freedom of thought and expression, belief, faith, and subject to law and public morality. So the objectives resolution is just more or less everything that the Constitution now represents. It's the sort of philosophical outline of the Constitution. And those are the three sources. The Government of India Act, the other constitutions, and the objectives resolution. Those are the sources of our Constitution. Now that we've sort of discussed a little bit about the sources, let's actually get into the Constitution and the different parts of it. So, change the color. Right. Now, the Constitution basically has three major sections, three major big chunks, or three major parts. I'm not using parts. I don't want to use the word parts because the Constitution itself has parts, Part 4, Part 5, etc. But it's divided into three big chunks, and they are the preamble, the articles, and the schedules. So, the preamble is an introductory statement to the Constitution of India. It is more or less everything that the Constitution holds within it, or the main values that the Constitution has. In the preamble, we have important words like sovereign, socialist, secular, democratic republic, justice, liberty, equality, fraternity. And these are all things our Constitution stands for. So the preamble is an introductory statement to the Constitution. Now, the articles are, I guess the articles should be pretty straightforward. They are all the details, all the points, all the features, all the laws, everything that's in the articles of the Constitution. And there are 395 articles in our Constitution. And finally, we have the schedules. And the schedules are like annexures. They provide extra information on various topics and sort of hot issues, etc. So the schedules are like annexures. One second. The schedules are like annexures, yes. And there are 12 schedules. 12 schedules. And these are the three big chunks of our Constitution: the preamble, the articles, and the schedules, which are like annexures. Now, the Constitution has a lot of different parts dealing with different aspects of governance and different types of topics. But one thing that's discussed in this chapter is the fundamental rights and the directive principles. And I know you've covered the fundamental rights and directive principles several times before, and believe me, you will do them several times more as well. But let's just go quickly into that. The fundamental rights. And the fundamental rights, I'm not going to write them down because that will take far too long, but they are in Part 3 of the Constitution. They are in the Part 3 of the Constitution. Part 3, and I'm going to use the Roman numeral thing. So Part 3. Right, of the Constitution, and they basically include all those basic rights. You've read about the 7 major fundamental rights in almost anywhere, right? Right to constitutional remedies, right to equality, right against exploitation, etc. So I'm just going to read a few out, and these are the basic inalienable rights of all citizens of the country, and they are enforceable in a court of law. So the rights include the right to not to be discriminated against on grounds of religion, race, caste, sex, or place of birth, right to equal opportunity in matters of public employment, the abolition of untouchability, freedom of speech and expression, freedom of conscience, profession, practice, and propagation of religious activities or religion, protection of cultural and educational rights, right of minorities, right against exploitation, etc. And these are our fundamental rights. Now, you also have the directive principles of state. You also have the directive principles of state policy. So write that down. Directive policy. And these are in Part 4. Part 4. Whoops. Part 4 of our Constitution. And this section, Directive Principles, contains all of these provisions that would be excellent if our country followed them. But unfortunately, these aren't enforceable, and because of that, they're not really followed all the time. And some of these would include the protection of monuments and places and objects of national importance, the equal pay for equal work, the aspiration for a uniform civil code, right to healthy working conditions for men, women, and children, protection to children against exploitation, organizations of village panchayats or local village bodies as units of self-government, etc. So that is the directive principles of directive principles of state policy and the fundamental rights. The next thing in the chapter is the Houses of Parliament. Change the color. Right. Now, India follows a bicameral legislative system. That is, it has 2 houses, and this is a key term here, so remember that. India has a bicameral legislative system. Bicameral legislative system, that is, it has 2 houses of parliament. 2 houses of the legislature, basically. 2 houses of the legislature. And we have the Lok Sabha and the Rajya Sabha, or the House of the People, which is the Lok Sabha, and the Rajya Sabha is called the Council of States. Now, the reason we have a bicameral legislative system is because India is a federation, and the center is stronger than the states. We know that, right? The center is always a little bit better than the state governments. But since India is so diverse and so different, it was thought that having a bicameral legislative system would be the most representative and the most efficient. The principle was one house would just not be enough to cover the entire diversity, so 2 is better. That's basically the reason the founding fathers adopted the bicameral legislative system. Now, let's just go into the numbers, the stats. The Lok Sabha has 552 members. 552 members. And out of these 552 members, 50 members are elected directly. So let's enter 550 are elected directly. And the other 2 are nominated from the Anglo-Indian community. So 2 from community. And then we have the Rajya Sabha. The Rajya Sabha is the Council of States. And the Rajya Sabha has 250 members total. And the 238 members are elected indirectly, so 238 elected indirectly, and 12 are nominated by the president. And that is our system of parliament. Let's move this down quickly. And the next two things we're going to talk about before I wrap this up is the provisions in the Constitution governing the center and state relationships. So the question here is, what can the central government do and what can the state government do? And what each tier of government can do is dictated by the different lists. We have the union list, the state list, and the concurrent list. Whoops. The union list, state list, and the concurrent list. Now, the union list has topics that only the central government looks after, such as defense and foreign affairs, etc. The state has topics that the states look after, like police services, prisons, agriculture, etc. And the concurrent list has topics that both the center and the state look after. That is education, newspapers, or family planning, trade unions, electricity, things like that. Etc. And anything that's remaining, anything residuary, remains with the center, because the center has stronger compared to the is stronger compared to the states. So we have the union list, the state list, and the concurrent list. And the last thing is emergencies. The president can declare emergency, and the emergency provisions are provided in Part 18 of the Constitution. So let me change the color again. Perfect. Move that here. Emergency. So these are dictated in Part 18 of the Constitution, and the president can declare three types of emergencies: financial emergency, state emergency, and national emergency. And national emergency is when there is a threat either internally or externally. Something like the failure of government constitutional machinery, or a war, something like that. That's where you have the national emergency. State emergency is when the president can rule any particular state by decree, as it happened in Jharkhand with Arjun Munda, who was there were problems there, and then the president ruled Jharkhand till the next elections. And finally, a financial emergency, which can be declared only in a time of crisis. And finally, the Constitution. All of these features that we've discussed are parts of the Constitution. But our Constitution has been amended 97 times. So it's called a living document because it keeps changing with the times and adjusting. And hence, it's considered a living document. And there it is. That's the making of the Indian Constitution.